Moderating this debate, first thing I need to tell you is to turn off all cell phones so we don't have any distracting noises during the debate. And I also want, as a preliminary matter, thank the law school's Hyatt Fund and the Law Students for Social Justice who organized this debate, especially Andrew Cunningham, who was in charge of getting the great speakers we have here today and setting up this whole program. Now, just by way of introduction, I want to say a few words. The death penalty obviously is one of the most important issues that confronts the criminal justice system today, not just because it's the most severe punishment that we have in the criminal justice system, but also because litigation over the death penalty has affected all other aspects of the criminal justice system, non-capital as well as capital cases. It's also a very emotional subject. Of course, first of all, there have been the many exonerations, people released from death row after witnesses have recanted, prosecutors have admitted that they withheld exculpatory evidence, or DNA tests have disproven the prosecution's case. At the same time, despite all of this, support for the death penalty remains very high, not just in this country, but also in Europe, where supposedly the death penalty is illegal. Well, not supposedly, in fact, it is prohibited. So a debate about the death penalty is particularly timely, especially since, as many of you may know, unless there's a stay granted or the governor commutes the sentence, tomorrow will be the execution for John Allen Muhammad, the mastermind of the 2002 sniping incidents in Washington, D.C., which left 10 people dead. For today's debate, we are very fortunate to have two very well-known advocates for their respective positions. They're extremely knowledgeable about the death penalty and veterans at debating its pros and cons. Advocating for the death penalty will be, against the death penalty will be Dr. Ken Haas, and I want to tell you a few words about him. He's from the University of Delaware. He received his PhD in political science from Rutgers University in '78. He's taught at Delaware ever since, and now has joined appointments in sociology and criminal justice, as well as political science and international relations. He's won more teaching awards at the University of Delaware than any other professor in the history of the University of Delaware. He's the author of several books having to do with criminal justice, and his scholarly work has been cited in many books and journal articles and by the United States Supreme Court. On the other side of the debate is Joshua Marquis, who served as district attorney of Clatsop County, Oregon since 1994. He's a former president of the Oregon District Attorneys Association and has served on the board of directors of the National District Attorneys Association since 1997. He was actually a criminal defense attorney for quite some time and represented 3 defendants in capital murder cases while he was a defense attorney. But of course, now he's a prosecutor. He's been a frequent guest on national radio and television programs where he's discussed the legitimacy of the death penalty. He's spoken in the United States Senate, European Parliament, and so on, and he's appeared on NBC's Dateline, as well as Good Morning America, The Rivera Show, and National Public Radio. So, this is the way the debate format will proceed. Each individual will speak from 5 to 7 minutes, laying out their general position, and then we'll allow 1 or 2 rebuttal by each speaker. So we may have 1 or 2 exchanges after the initial presentation, and then with about 20 minutes left, we'll open up the floor for questions, and then with about 5 minutes left, we will take the vote. And probably most of you know we are going to engage in the voting process in a way that's a little bit different than normal. We're not going to ask for people to raise hands. Rather, we're going to follow the Oxford format, which means that if you believe that Dr. Haas made the best argument, this is not, by the way, a decision about what your preconceptions are about the death penalty. You are voting on who made the best arguments, not whether you agree or disagree with the death penalty. It was who was the best debater. If you believe Dr. Haas was the best debater, you go through this door on your left, which sort of makes sense. If you believe the anti-death penalty position wins, you go to the left. If, on the other hand, you believe that Mr. Marquis was the best debater, you go out that door over there. And we'll do that with about 5 minutes left. Now, the first presenter will be Mr. Marquis. That was determined by a coin flip. We flipped a dime, and it came up heads, so Mr. Marquis will be the first speaker. Without further ado, Mr. Marquis.
Thank you. My name is Josh Marquis. I'm the district attorney in Clatsop County. Most of you probably have no idea where that is. If you've watched movies like Kindergarten Cop, The Goonies, Free Willy, it's all filmed there. And by the way, I'm going first because Professor Haas won the coin toss. I always prefer to be in the rebuttal, but and we've agreed to try to keep our opening statements as brief as possible so there's as much interchange. I want to put one thing, I want to start right off And I'm not going to hold you to this. Those of you who are opposed to the death penalty, would you raise your hands? Okay, roughly 2/3 of the audience. That's generally, I debate this for both the Federalist Society and the American Constitution Society around the country, and that's pretty standard. That, of course, is the exact flip-flop of the general support in the American population, which, depending on how you ask the question, runs between 65 and 80%. The way Gallup asks the question is, do you think murderers deserve the death penalty? If you were to ask me that question, I would say no, generally not. I've been handling capital prosecutions for 19 years, and I've stood before juries only twice and asked them to put someone to death. One, the same defendant, twice, the jury said yes twice, and the other, a defendant where the jury said no. So the death penalty is although it's an extremely emotional subject, it is a penalty that should be very rarely sought, rarely asked for, rarely imposed. And in fact, that is the case. Since the modern era of capital punishment, Gregg versus Georgia, in 1976, there have been roughly, unfortunately, about 700,000 murders in the United States. Slightly over 1,000 people have been executed. Now, if you were to ask me, I would suggest that many of the people on death row shouldn't be there, not because I think they're innocent, but because I don't think their crimes are heinous enough. The idea is that the worst of the worst. Now, when you ask the question on the Gallup question side, do you think murderers deserve the death penalty? Again, generally not. In fact, of all crimes, murder is one of the least likely to recidivate. Most murderers are not going to commit that crime again. On the other hand, if you ask, and 65% roughly of Americans right now answer that question yes. It was up to about 80% in the 1980s when crime was really bad, and it came down for a variety of reasons. If, on the other hand, you ask the question, is there any crime for which you think the death penalty is appropriate? You get about 80 to 85%. My wife's a good example. She's very much an agnostic on the death penalty. Is not very fond of the fact that I go around the country talking about it. I was a journalism undergraduate. The first thing they do in journalism school is make you write your own obituary, which at 19 is usually not very interesting, so you're supposed to project out. I do not want my obituary to read Joshua Markey, 92 prominent death penalty proponent. I care very much about victims' rights, animal cruelty, DUII, a lot of other things. I'm just willing to talk about this, which is why I'm here. And to disabuse you of the idea that this is a right-left issue, I've never voted for a Republican for national office in my life, and don't expect to. This is not a right-left conservative Republican issue. In fact, the position of President Obama is that there are some cases in which the death penalty should be imposed. What has happened in this country is very interesting because in Oregon, we've popularly abolished and reinstated the death penalty 4 times just in the 20th century. We're a very populous state in Oregon, and most recently reinstated it in the late 70s. I remember when I was 12 putting a bumper sticker on my dad's car, who was a professor at the University of Oregon, that said abolish the death penalty. And at that time, 65% of Oregonians thought it ought to be abolished. There are about 36 people in Oregon's death row. Only 2 of them have been executed, and they are what in the vernacular we call volunteers, meaning people who say, I want to waive my appeal. It's like Tim McVeigh. Mr. Muhammad, for example, who may be executed tomorrow, is not a volunteer, although he has made some rather bizarre statements like that he wants to be executed so that an innocent black man will be executed in the United States. Mr. Muhammad killed 10 people. And we all know Mr. Muhammad's name. Very few of us know the names of their victims. And that's one of the things in the debate I think that needs to be talked about. Originally, the debate in America about the death penalty was, is it moral? And if you believe that the death penalty is wrong for moral or religious or philosophical reasons, there is nothing I can say that is going to change your mind. There is nothing morally superior about my position than yours or Professor Hawes's. So in about 1995, a guy named Richard Dieter at the Death Penalty Information Center, very well funded by a number of people, the guy who owns Progressive Insurance, George Soros, some other people who are against the death penalty, changed the debate and said, okay, well, maybe the death penalty is appropriate, but it's racist. People who face the death penalty get inadequate counsel, and the biggest one of all, what about innocent people being executed, which is a very legitimate concern. And I will tell you, as a death penalty prosecutor, innocent people have been on death row. Probably 36 since 1976. Now, I would argue to you that the number of innocent people that have been executed is zero. There is a case right now that I really don't know the answer to that was written about in the New Yorker, a guy named Willingham who was convicted of the arson murder of his children. But until Mr. Willingham's case, the great innocent person acquitted was a man named Roger Coleman, who was on the cover of Time magazine. He was executed in 1992 for the murder of Wanda McCoy. Victims' names matter. She was 19 years old. She was his sister-in-law. He raped and murdered her. And the state of Virginia, as in Mr. Muhammad, executes people relatively quickly. He committed the murder in 1980. He was actually executed 12 years later. The guy I have on death row in Oregon has been there for 19 years, and we're about to do trial number 4 in March. Even if he's given the death penalty, I suspect he will outlive me. In Roger Coleman's case, he went to his death claiming that he was innocent, and someday people would realize it. In 2006, the outgoing governor of Virginia, Mark Warner, in Virginia, governors can only serve one term, agreed to test this one last tiny remaining bit of DNA. And their Nightline gathered, and Jim McCloskey, who runs something called Centurion Ministries, who believed totally in Roger, was going to have this big rollout. January 2006, the answer came down, Canadian lab, without really, well, 1 in 19 million chance that he was not, in fact, the killer of Wanda McCoy. Now, does the fact that one person, in fact, who claimed not to be guilty, was guilty, make the death penalty okay? No, it does not. But I don't know how I'm doing on time. I got 1 minute. I'll end with asking you to read a paper by someone who is currently before the Senate named Cass Sunstein. He's a very progressive law professor at the University of Chicago. He's a friend of the president. And he wrote a paper in 2005 called "Is Capital Punishment Morally Required? A Life-for-Life Trade-Off." And Cass Sunstein is not a hardcore death penalty supporter. In fact, I think he may even personally be against the death penalty. But his point was this: a series of studies in the last 10 years have shown that the deterrent value of the death penalty actually exists. And this is done by non-ideological, in many cases, regression economists, that for every death sentence, 17 murders plus or minus 7 are prevented. And Sunstein's point, very controversial, is if the death penalty actually prevents hundreds of people from being murdered, how can you not have it? And I'll end by saying that I support capital punishment in the same way I support abortion. I don't think abortion's a good idea, but I think it's a choice. I think it's sometimes a necessity. I think it's something that should be available. And my position is the same on the death penalty. Thank you.
Dr. Oz?
Okay. Well, we are going to see some confusion of ideological labels because I have frequently voted for Republicans. I consider myself one of the more conservative faculty at the University of Delaware and the American Academy generally. And it's my position, in fact, that opposition to capital punishment is basically truly a conservative position, at least if we define conservatism in terms of the work of Edmund Burke or the great Russell Kirk, not in terms of idiots like Bill O'Reilly or Glenn Beck, who are not conservatives but radical dummies. In fact, I don't like to think about obituaries because I'm a little older than Josh, but I would hate it if my obituary were to say and focus that, Ken Haas is best known for being a liberal, bleeding heart crybaby who shed tears for murderous killers. Oh, Lord, no. In fact, let me, to explain my position on capital punishment, let me tell you that I am not a Witherspoon excludable. Now, a Witherspoon excludable is a juror whose positions on the death penalty tend to be pro-life and cannot truly be fair to the prosecutor's arguments for the death penalty. In Witherspoon versus Illinois in 1968, the Supreme Court said that somebody who merely had conscientious scruples against the death penalty could not just be removed from a jury for cause. And the court then used the definition that anybody who would automatically vote against capital punishment could not serve. A few years later, the Supreme Court clarified that in the case of Wainwright versus Witt in 1985 and said that any prospective juror whose views on capital punishment would prevent or substantially impair him from being fair in accord with his oath and his instructions cannot serve. Well, I could serve on a capital jury, and if Josh convinced me that the defendant committed a serial murder and tortured people, and the proof was there beyond a reasonable doubt, although I would prefer beyond a conceivable doubt in death penalty cases, I would most certainly vote to convict and in favor of the death penalty. And so I do not shed a tear at all for these killers. I'm not particularly concerned about whether there's a last-minute reprieve for John Muhammad. I'm kind of rooting against it. In fact, I have a bet on it at Delaware Park. So my position is that, in fact, that I'm not surprised that a Democrat would support capital punishment, because if you want a good example of the most wasteful and ineffective, benefit-free government program imaginable, it is our current government program on capital punishment. It's extraordinarily expensive, and contrary to these studies, which appear periodically by economists, and I'll explain why their research is so horribly flawed, the death penalty doesn't have any superior deterrent effect to life imprisonment without parole. In fact, let's do some common sense. We don't even need studies to know that. Now, does the death penalty deter murder? Of course it does. But it's always a matter of comparison. If the question were, does the death penalty deter murder that better than a $100 fine? My first question several years ago when I quarreled with my chair would be, where do I pay and where's Bob? You know. But will the death penalty deter better than life imprisonment without parole? Of course not. Only rational people, and this is one problem with economics, though it's a great field. I disagree that it's the dismal science, as some call it. I never said that. But they tend to look at models that assume rationality. No rational person would ever take the position, well, I'm going to go ahead and kill my spouse for the insurance money because if I get caught, I'll only get life imprisonment without parole. I'll only get. I mean, there's this notion somehow among people that if there are two different punishments and one is more scary than the other, that the scary one deters better. Nonsense. If you had a choice between your punishment being 500 years or 100 years in hell, I'm sure you'd choose 100 years in hell. But believe me, either one would be enough to deter you. If you weren't eating lunch, I would use the example for young males, since you're the most likely to commit a murder, that if you had a choice of a punishment between having your eyes poked out or your testicles squeezed into a little mush, one of the two might scare you more than the other, but I assure you that both would be enough to deter you. No rational criminal capable of being deterred would ever say, I'm willing to commit the murder because I will only get life without parole. On the other hand, people on the fringe of sanity, people who feel, the typical murderer who feels betrayed, humiliated, dishonored, the victim of a vast conspiracy. For him, the message of an execution, especially a highly publicized one, is imitation. The message is that violence is an acceptable way to resolve the problems with those who do us wrong. And in fact, the best scientific evidence indicates that if anything, executions have a slight brutalizing effect and actually lead in short-term studies to a slight increase in the homicide rate. So not only does it not deter, but if anything, it makes us less safe. So my position is basically that a true conservative who wants cost-effective programs that will work should oppose capital punishment. Moreover, I want to point out that the problem with the death penalty is people. I support the death penalty. Josh says it's a question as to whether or not you can morally oppose capital punishment. I have no moral opposition whatsoever to capital punishment. I think it's absurd to say that it's immoral unless it's based on your true religious beliefs. But the question is, does it work? And as we'll see, the answer is no. I support the death penalty in principle, but not in practice. And the reason is that ever since Eve bit that apple, which is really Adam's fault, human beings have been, as Nietzsche said, all too human. We're morally and perceptually fallible. Capital cases, all criminal cases, will always be plagued by cases of mistaken eyewitness identification, coarse confession. Well-meaning police and prosecutors who get caught up in what Jerome Frank said was the pursuit of victory over the pursuit of truth. It's a classic psychological process. You have one theory of who did the crime, and the first bit of evidence tends to support it. The police, the prosecutors tell their spouses, their friends, we got the guy, we got the guy. Then they tend to ignore any evidence to the contrary. Case after case that comes to the U.S. Supreme Court, we find situations like that. Well-meaning people thinking they're doing right are the ones who are constantly screwing up and making errors. The death penalty, history has shown from ancient Babylon through the Roman Empire through today, simply cannot be administered by human beings without substantial error, substantial caprice, tremendous waste of money, and a great deal of racial, gender, and class bias. It just can't be done.
Dr. Ross, why don't we stop there and let
Fair enough.
Mr. Marquis respond, and then we'll let you come back.
5 minutes, right?
Or
Roughly,
so, yeah.
okay. Professor Haas has presented a classic conservative, which is if you don't, how do you like the TSA? If you don't like the TSA and the Department of Motor Vehicles, do you really want the same institution deciding whether people should be executed? Probably not very positive. But the idea that and Professor Haas has actually articulated what is the most recent argument against the death penalty, which has gone beyond the moral and frankly now beyond sort of the innocence issue to the cost issue, which is highly relevant during this enormous recession where so many other things are needed, education, healthcare, et cetera. The fact of the matter is the reason it costs so much is because we give people due process. The only way to save money would be to withdraw that due process, which would be wrong on every level. And frankly, not only do murderers deserve due process, but anybody we're going to lock up for long periods of time deserves due process. I am outspent in Oregon 20-1 when I try a capital case. Now, I know that's not the conventional wisdom. The conventional wisdom is the threadbare but plucky public defender coming in with the battered briefcase and the district attorney sleek with his 3 or 4 assistants sweeping in on a limo. That happens in John Grisham novels and on TV and movies, but not in real life. The death penalty is a very specific deterrent in one way. Ted Bundy is not raping and murdering any more people because Ted Bundy is dead. And in states like Michigan, for example, which have not had the death penalty since 1858, has one of the very highest murder rates. One of the problems is you have people in prison doing life in prison, and what do? They murder other people in prison. They other prisoners, they murder guards. Senator Dianne Feinstein tells a story about when she was on the parole board in California, and it was a woman not charged with murder but robbery. And she was asked, well, you had a gun, but the gun wasn't loaded. Why did you do that? And Senator Feinstein the woman says, well, I know California's got a death sentence, and I did not want to carry a loaded gun because I didn't want the chance for that to happen. Is murder a rational act? Rarely. But look at, is it a crazy act? Yes, in one sense. The crime for which the execution may happen tomorrow, John Muhammad, was an incredibly calculated, premeditated crime. 10 people were murdered and 3 were gravely injured. I ask you to think in your mind in terms of justice. Is there any crime, the murder, torture of a child, the killing of a large number of people? I think we can all agree the Supreme Court is right. Retarded people should not be executed. People with serious mental illness should not be executed. Juveniles should not be executed. So then the question comes down to, are there any circumstances, and what is the alternative? Life without parole. But then I would warn you, the sentencing project run by a guy named Mark Maurer, very well funded, very articulate guy. In fact, I was just on a panel with him at the ABA. They came out with a project called No Exit in July of this year, in which they call for the abolition of life without parole. I debated Nadine Strawson, who is used to be the president of the ACLU for the United States at the ABA convention just before 9/11. And I asked her, it's available online, I said, look, I really, and I meant this sincerely, if I could be absolutely convinced that someone would be locked up for the rest of their life with no possibility of release, I would probably be willing to give up my support of the death penalty. But I need to know, as the head of the ACLU, will you agree that life without parole does not constitute a violation of the 8th Amendment, that it is not cruel and unusual punishment? And she gave me a very honest answer. She said, nope, can't do that. It's an evolving moral standard. So One of the reasons that a lot of cases don't go to trial, and I can tell you this as a practitioner, both as a defense practitioner for a relatively brief time and a prosecutor for a longer period of time, that the only reason many cases are resolved is that the specter of the death penalty is over them. Now, any prosecutor that uses that when it's not appropriate is committing a grave violation of office. And one of the reasons that it takes so long is that we have layer after layer after layer of appeal. And the reason we know about many of these cases where mistakes were made, and mistakes were made, no question, is because the man, for example, I have on death row, has committed his crime 22 years ago. And there's not really any real issue about whether he did it. The issue is whether the jury can answer all 48 questions yes, which is what Oregon requires before someone's put to death.
Let Dr. Marquis respond now.
Dr.
I mean, sorry, Dr. Haas. Yeah, excuse me.
Josh just made a very good point. And I almost wish I were debating Nadine Strassen because it is true that when we abolish the death penalty, that people on the far left, mainly Democrats, will in fact argue that life without parole is cruel and unusual punishment. In fact, at this very moment, not quite this very moment, but the Supreme Court is hearing oral arguments today in two cases from Florida, the argument being that it violates the Eighth Amendment to sentence juveniles to life imprisonment without parole. What I think is going to happen, though, is that when this court looks to objective standards of decency, it's going to find that the vast majority of states do permit the sentencing of very, very serious juvenile offenders to life without parole, and therefore the court will probably find, although you never know, that there is no contemporary consensus against that practice. I think once we get rid of the death penalty, which is an illusory remedy, a symbolic remedy that makes the people feel safer than they are, that we can then get to the serious issue of determining what kinds of punishments are the fairest and the most retributive punishments for various kinds of offenders. Now, by the way, Josh is doing a great job, but words have meaning, and we have to be careful how we use words because they lead to ideas, and ideas have consequences, some good and some bad. It is simply incorrect to say that the death penalty has a specific deterrent effect. Specific deterrence refers to the ability of a punishment to intimidate a living creature with free will from doing something he otherwise would do. You can't specifically deter a dead person. You can't specifically deter this podium. He means to say incapacitation, of course. The death penalty does have an incapacitation effect, but the death penalty does not have a specific deterrent effect. It does not have a general deterrent effect. Now, what about that incapacitative effect? It is true. A study of the inmates whose lives were saved by the Furman versus Georgia decision did show that among those who stayed in prison, 4 of them committed new murders. However, those who got out did very, very well. The vast majority never went back to any crime. It is true that there are some people who will kill again in prison, and some who are even clever enough perhaps to escape from prisons. But that's another thing we can work on and maybe have the money to do better once we get rid of the death penalty. Because believe me, a society that can send people to the moon darn well ought to be able to figure out a way to keep dangerous people in prison and keep them from hurting anybody while they're there. I know we can do it. Other nations do it. All of Western Europe has abolished the death penalty. When they get those kinds of offenders, they get life without parole. They rarely hurt anybody else. It can be done, and it'll be easier to do that. It also always amazes me that the very same people who talk about who downplay the incredible number of errors that are made in capital cases will play up the kinds of errors made by parole board officials and prison officials that lead to releasing people who are truly dangerous or allowing people to escape from prison. This is the problem. Human beings are all too fallible. We constantly screw up, and it will always be that way. We can't trust ourselves with irreversible punishments. And as for the notion that we provide due process to death row inmates, nothing could be further from the truth. In fact, we have one of the strangest appeal systems in the world. Take a look at the case Herrera versus Collins. In that case, the Supreme Court agreed to decide 2 issues. One, does it violate the cruel and unusual punishment clause to execute an innocent person? Well, the court couldn't answer that question, finding it too difficult. I find that easy to answer. Executing an innocent person is certainly the gratuitous infliction of pain and suffering with no good coming out of it. 5 justices in the various majority concurring and dissenting opinions did take that position, but that does not an opinion make. The other question was whether or not a death row inmate could bring a freestanding claim of actual innocence if he didn't also have a procedural claim, a grand jury error, an exclusionary rule error, a Miranda rule error, and by that I'm opposed to the Miranda rule. And the answer was no. Actually, Rehnquist's answer was first no, and then maybe. If a truly persuasive case were shown, then perhaps we could do this, but the standard would have to be extraordinarily high. The result is that we have an appeal system now by which murderers often have their death sentences or convictions reversed because T's weren't crossed and I's weren't dotted. Meanwhile, people with actual, reliable cases of innocence, new evidence of innocence, aren't allowed to appeal. And this has worsened since the passage of the 1996 Anti-Terrorism and Effective Death Penalty Act. What kind of an appeal system takes away largely the opportunity to make a claim for the truth, to bring up evidence of innocence, and instead ask us to mainly consider, did we get the procedures right? Did the police officer make a search error, which a court found 5-4 that he made wrong? Absolutely absurd. There is virtually no due process in these cases at all. We need, among other things, to change the appeal system to allow death row inmates and all inmates to appeal on the basis of innocence and not on the basis of procedural technicality. So we need to move away from that.
So why don't we give 2 more minutes to each speaker, and then we'll open it up for the audience.
I would agree, with Professor Haas, that the idea that executing an innocent person is not a violation of their most fundamental rights is ridiculous. But I will also tell you as a practitioner, this is not, no offense to Professor Haas, my father was a professor, an academic exercise for me. I live in a relatively small county. When I make the decision to seek the death penalty, I meet with the victim's family, and I stand as close as I do to Professor Haas to the person of whom I'm seeking to ask the jury to kill that person. So this is not academic. It is very real. It is a decision that I don't think I am special among prosecutors in taking it incredibly seriously. So Professor Haas has said, well, it really doesn't do any good because human beings are fallible. Yes, they are. Psychologists will tell you that the best predictor of future behavior is past behavior. But that doesn't just apply to individuals, it applies to institutions as well. And Professor Haas might even agree with me on that. And in my state, until 1994, when someone was sentenced to life in prison for murder, it meant 8 years. When someone was sentenced to 20 years in prison for forcible rape, it meant 3 years. Ridiculous. And so voters passed mandatory sentencing laws that actually meant that a rapist, someone who grabs a 12-year-old girl off the street and violently rapes her, gets 8 whole years in prison. If I made a wild guess. Now, the fact of the matter is, when we take away 8 or 10 or 15 years of a young man's life, that is in many ways also an irrevocable act. And why do we do that? Do we do that because we think it's going to make them a better person? That they're going to get cured of their pedophilia or their incredible anger towards women? No. We do it, and I think Professor Haas and I may actually agree on this, because retribution is different than revenge. Retribution is a reasoned moral response to a terrible wrong committed against both an individual and against society. And for the same reason that we deprive someone of their liberty for repeatedly molesting children for 10 or 15 years is the reason that in some very few cases, and I ask you to think to yourself, is there any case, whether it's the Nuremberg war crimes or Ted Bundy or perhaps some other awful case you've heard, that you say, well, I'm really not for the death penalty, but that person deserves to die? Because if you answer that question yes, then you have crossed that Maginot line or that Rubicon, and you've answered the question about whether the death penalty should be. Then the question about how we make sure that there are as absolutely few mistakes as possible is very important, because Professor Haas is right, there will always be mistakes. Justice is a work in progress. We are never doing it perfectly, any part of it.
Professor Haas?
Okay. I wanted to I brought some materials just to give you some examples, some typical events in a year in the life of the death penalty in 2009. One of the more interesting events that caused a little bit of a furor among the defense bar and the prosecutorial bar was a new study by the National Research Council, the National Academy of Sciences, which stated, and this is the most prestigious scientific research organization in the country, with the exception of nuclear DNA analysis, no forensic method has been rigorously shown to have the capacity to consistently and with a high degree of certainty demonstrate a connection between evidence and a specific individual or source. Fingerprint analysis, large element of human interpretation in the fingerprint analysis. Tool mark and firearms identification. Because not enough is known about the variables among individual guns, we are not able to specify how many points of similarity are necessary for a given level of confidence in the result. Microscopic analysis of hair. The hypothesis that microscopy can individualize a hair source has no scientific support. Bite mark evidence, even worse. The defense bar was exultant, of course. Prosecutors were upset, but the best answer, and the one to which I agree, was provided by Josh Markey, who said, a quote, the next week in the National Law Journal, and he couldn't be more right, quote, the science of this has been tested over and over again. The problems are not with the science, but with the people who apply it. Exactly right, the people. These mistakes are extraordinarily common. And we have to realize, I've seen some arguments on the death penalty that the cases that go wrong, it's the same principle as the press will not report on all of the planes that land safely, only on the very few that crash. When it comes to the death penalty, what's really happening is that the vast majority of death penalty cases are systematically flawed and go wrong in one bizarre way or another, and it's not reported on very well by the media, and the people don't know about it. How much time do I have?
Maybe 30 seconds.
A few other quick events. In October, a new study showed that in the 39 states where judges are elected, state judges, the research shows that these state judges are more likely to impose the death penalty when they have elections looming. Well, wonderful. Some of you may have studied the 2009 Ohio Supreme Court decision, Disciplinary Counsel versus Stewart. What happened there? Well, the judge in Ohio sentenced a man to death and wrote his order. Only the prosecutor in the case ghost wrote the order for him. The prosecutor wrote secretly. The judge and the prosecutor conspired secretly, and the prosecutor wrote his death sentencing order. Well, in Disciplinary Counsel versus Stewart, the Ohio Supreme Court took a strong stand, gave the judge and the prosecutor a public reprimand, and they promised not to do it again.
Let's end there. And
I have many more I can go on. Just Google death penalty bizarre errors, millions.
Okay. So we want to have about 10 minutes of question and answer. Feel free to ask any question. I might let both speakers respond to each question, even if you address the question just to one of them. Yeah, go ahead.
I'm sorry, I forgot your name.
Professor Haas.
Mr. Haas.
Sorry,
Mr. McKee.
So you focus in on this issue of unavoidable error because we're all human.
Yeah.
And to what degree is the issue of, does that apply to either the issue of executing innocence or providing a stronger deterrent? You seem to move between both in your analysis of human error. I'm wondering for you which issue is more important.
Well, they're both very important. When it comes to deterrence, the one thing research has shown now for 200 years is that certainty of punishment is far more important than severity of punishment. In other words, if you have 100 murders and you only catch one murderer and you give him the worst type of execution imaginable, that won't have much of a deterrent effect because most murderers will correctly know they're not going to get caught at all. In fact, research with prisoners shows they don't even begin to think about the severity of the punishment until they're arrested. Then they want to know what the punishment is, and then try to get a good plea bargain, of course. And so I think the two issues are separable. The problem with the errors, I don't think in fact, even if we have a lot of errors, the more errors we have, that would mean the more executions, and that might increase the deterrent effect. But that just would be an inhumane thing to do. In Herrera v. Collins, I often joke with my students, like, my goodness, why are you complaining that you should head into sentencing hearing? You had a fair trial. You were unlucky enough to have a fair trial. Not a good trial, not an excellent trial, but you got a C trial. There were no major errors. Any small errors were subject to harmless error analysis. Now you have a video that you were in Alaska, 500 miles away from the scene of the crime. Why be insisting? Take one for the team. Take one for the team. The victims will be happy. They think you did it, so they'll be happy when you're executed. There'll be deterrent effect, to the extent there is a deterrent effect, because nobody will think that you're innocent. And so take one for the team. So I think the two issues don't come together. And I think the best way to achieve deterrence is to use the money wasted on the death penalty and use it to, let's solve cold cases. Let's improve forensic laboratories and move away from these incredible errors that are being made. So in the case of Todd Willingham, where modern arson investigators said, there's no way this was an arson. The original investigation that condemned him to death for that arson murder was absurd. They said they found patterns of the devil in the fire burns. What did Governor Rick Perry do? Immediately fired the Forensic Science Commission that's investigating this and appointed his old friend, the head, who promptly canceled that coming meeting, which was bringing in the best arson investigators. And what the Roger Coleman case to me was that before they finally showed that Roger Coleman was a murderer, the state prosecutors in Virginia fought against doing that new DNA testing. What were they afraid of? What are they trying to hide?
Did you want to respond in any way?
Yes. I got to get one thing in about the judges that are elected or more likely. Ring versus Arizona. Some of you hopefully know about that. Supreme Court case says, guess what? Judges don't get to impose death sentences. Juries have to do it. So judges in this state, in this country now, can overturn a death sentence, but they cannot impose one that a jury has not approved. But to answer your question about the possibility of errors, there's a study called the Liebman study. Originally came out in the mid-90s. Professor James Liebman, Columbia, showed roughly 2/3 of all capital cases overturned. And the thesis was, my God, 2/3 of the cases overturned. That must mean that there are errors rife throughout the capital system. So, but when you start looking at the individual cases, are they because they are these, again, Grisham-like situations where a person is wrongly accused? No, it's because of the level of due process we apply. The one case I've got on death row, the issue that returned the case was that the victim was allowed to get up, the victim's family was allowed to get up on the stand during the penalty phase and tell the jury a little bit about what Rod and Lois Hauser were like as human beings. Not what they wanted to see Randy Guzik dead. And the Oregon Supreme Court said, well, you know what? The statute says that you can do that in a shoplifting case, but it doesn't specifically say that you can have victim impact in a capital case, and therefore we're going to reverse it. And by the way, you're going to have to do the trial all over again. The fact of the matter...
Let's go on to the next question.
Okay.
Let's make sure we get some more in.
Can I respond to that?
Okay, very briefly.
Okay. Josh misstated Ring versus Arizona. It is not true to say that Ring versus Arizona says that only juries can impose a death sentence. In fact, Ring versus Arizona allows several states, including Delaware, Indiana, Alabama, Florida. The jury simply plays an advisory role and votes, not unanimously, 9-3, 8-4, 7-5, 4 against the death penalty. The final decision is made by the judge. And in the states that have that system, that's been upheld under Ring. Most of those laws say that the judge is to take into very strong consideration the jury's recommendation, but the judge makes the ultimate decision. So Ring at this point stands only for the proposition that a jury must be involved in some way in the trial level sentencing process, not that they can't actually make the final trial level decision.
Okay. Yeah, let's, by the window there.
In your opening statement, Mr. Murphy, you made much of the fact that you don't know of any cases where an innocent person has been executed. Would it make a difference if you did know of a case? And if it does make a difference, how many cases would be enough to change your position on?
Well, I guess I don't want to be flippant, but it would be sort of like an alcoholic. One is too many, and 1,000 is not enough. I have to be honest. If you have a death penalty, is there a possibility an innocent person will be convicted? I would say yes. There is that possibility. I don't know. The Willingham case has many, many aspects to it, not all of which have been fleshed out in the New Yorker. The question comes down to basically, and this sounds harsh, but it's what Professor Sunstein talks about, cost-benefit analysis. You are more likely to be killed by your pharmacist than you are to be wrongfully accused of a felony in this country. 44,000 of you will be killed by medical errors this year. So the point that Professor Sunstein makes is when we know that there are hundreds, maybe thousands of people, innocent people, who will die, who will be murdered because we don't do it, can you afford not to do it? But to answer your question, yes. I think there is a possibility, and it's a very disturbing possibility.
Just want to say anything in response to that?
No, wait for
Okay.
some more questions.
Yep. In the back there to the right, yes.
In talking about victims, how are they affected by the death penalty? Do they find foreclosure, or is having to witness the whole appellate process completely?
Can I answer that?
You can both answer that, okay? Briefly.
Okay. I'd like to talk about victims because one of the great points that Josh made was that it's so important to remember the names of these victims. One point Josh makes in a recent law review article co-authored with Paul Cassell, a friend of his and acquaintance of mine, is that just the defense part of the Timothy McVeigh case cost $13.5 million. And what was that for? $13.5 million just for the defense. Was that a good use of government money? Timothy McVeigh, John Ashcroft arranged for a closed-circuit TV viewing of family members of the 168 victims who wanted to attend. Now, here we're going to execute a guy who killed 168 people, and he referred to the children as, quote, collateral damage. What did the death penalty do for him? What it did for him was give him a chance to come out and smile and smirk. Most of those victims left that closed-circuit hearing feeling worse than ever. And the death penalty often makes these people into celebrities. They get fan mail. They often smile and taunt their victims in the execution chamber. And the idea of this closure is the most overused word by people in support of the death penalty. The social science research shows that executing the offender of the murder of somebody's loved one does little or nothing to bring back a sense of joy and freedom. The way to handle these things is the way Judge Brinkema handled the case of the 20th hijacker, Zacharias Busali, in sentencing him to life imprisonment without parole. The last words she said to him before he left the courtroom was, "You will die with a whimper." There was no smirk at that point. That's how we need to deal with these kinds of killers, not with the death penalty.
Closure never happens. I never use that word. And by the way, again, this is not academic for me. I sit down. I have in fact waived the death penalty because families have said to me, we do not want. I've taken this into consideration. It's my decision. I'm the gatekeeper. But if a victim, under the Oregon Constitution, and I fought for this to be in the Oregon Constitution, prosecutors must consider the wishes of victims. My guess would be, having done this for 19 years, about 75 to 80% of the victims of capital cases, in fact, do want the killers of their loved ones executed. Do they get closure from it? No. They get some degree of finality from it, which they don't get when the person is in prison for the rest of their life. But I want to point out, because I do know Professor Cassell, and one of what Professor Cassell did is he sued the Department of Justice because the court system in the McVeigh case was so numb to the victims' wishes that they refused to make access to many of the victims in the McVeigh case who didn't have the money to travel to Denver where they'd moved the trial. So Professor Cassell sued them so that they would have to set up so that they could at least participate. And I can tell you from being there that the trial process, frankly, no matter which way it comes out, is an incredibly cathartic process. And the most amazing and eloquent things I have ever heard are the victim impact statements in both capital and non-capital cases. And I stay in touch with these people over the years. And they often say, I am so glad I had the chance to say that. And this is really respective of both capital and non-capital.
We have about 5 more minutes, so we have time for 1 or 2 more questions. Against the window there.
My question is for Mr. Markey. I think a couple weeks ago, the American Law Institute came out and they created, I believe, the model death penalty statute that allows states to adopt it. I know Tennessee based their statute almost identically on the model statute from ALI. And they just came out a couple weeks ago revoking their, I guess, recommendation to use their own model death penalty statute because it's unworkable. They said, as of right now, we just cannot endorse this. We have to withdraw, and they recommend that to the council. So at the time right now, the creator, I guess it's a model death penalty statute, says it's not workable. What should we do with that?
Well, I'm about to litigate that very issue. There's a professor named Wanda Folia who goes around the country testifying that there is no way to have a death sentence or a death mechanism which is workable and which a jury can understand. And of course, guess what? Professor Folya and her supporters oppose the death penalty. You can create a Rube Goldberg mechanism that is so complicated, so difficult, so hard to understand, so hard to implement that it is the functional abolition. In Oregon, you have to answer four questions. The jurors all have to agree, was the murder not merely intentional but deliberate? Did the victim do anything to provoke it, mainly to prevent battered women from being subject to the death penalty? Is there a strong likelihood that the person will commit future acts of serious violence in the future? The state, by the way, has to prove these first three questions beyond a reasonable doubt to all 12 jurors. And finally, just an open question, should the death sentence be imposed? Are there mitigating factors that argue against it? And if there's 47 yeses and 1 no, the death penalty is not imposed. As much as one can create a mechanism, I think it's probably as close to fair. I'm sure there's a better way to do it.
I'm not sure I heard the question, but was it about the American Law Institute recently declaring that it withdrew the capital punishment section of the Model Penal Code? Yeah, that study came out in October, and quote, we're going to withdraw it because of the currently intractable institutional and structural obstacles to ensuring a minimally fair system for administering capital punishment. And nothing could be more correct. Josh is correct, by the way, about the cathartic importance of a trial and victim impact statements. And another ideal example of how to proceed is Colin Ferguson, the Long Island Railroad shooter who killed 6 people and wounded 19 others in a 1993 shooting. This is before New York embarked on its ambitious death penalty experiment and spent $60 million and never executed anybody. And there was no death penalty at the time. So he quickly went to trial. A year and a half later, he was found guilty. The victims gave tremendous testimony and told him exactly what they thought of him and what he had done to them in their lives. And then the judge sentenced him to life imprisonment without parole. He's never been heard from again. He no longer is a celebrity. The victims have been able to get on with their lives. Once we get rid of the death penalty, that's the way we'll handle things, the same way every civilized nation does. And we're going to use that money properly. We're going to increase the certainty of punishment and do what the National Association of Chiefs of Police just said in a recent report. When they asked what is impeding the effort to fight crime, 20% said lack of police resources, 20% said drug and alcohol, 2% said insufficient use of the death penalty. And also this conservative group, the Association of Chiefs of Police, when asked, is it true that politicians use the death penalty to distract people from the real causes of crime and how to really deal with it? 72% said, yes, that is true. Now, these are chiefs of police, those liberals. The consensus is becoming clear. The death penalty is a dying institution, and it's only a matter of time before we follow the rest of the civilized world in this regard.
Why don't we do this? For 30 seconds, I'd like each of the speakers to sum up, if you want to, starting with Professor Haas and then with Mr. Marquis, and then we're going to take the vote. Just 30 seconds.
Okay. Well, the death penalty inevitably leads to error, caprice, racial discrimination. The famous Balda study showed in Georgia showed that even after the changes brought about by Furman versus Georgia, out of every 100 cases where a black was convicted of killing a white, all other factors held equal, 22% got the death penalty. When a white killed a white, 8%. When a white killed a black, 3%. When a black killed a black, 1%. So, white kills a black kills a white, 22% get the death penalty. Black kills a black, 1% gets the death penalty. Same results in every state that has been studied. Jack Boger study in North Carolina, study in California, Ray Paternoster study in Florida, in Maryland. We simply can't continue to have an irreversible punishment where we know we will make some mistakes, where we waste a lot of money, and we invariably commit horrendous racial prejudice. Got to get rid of it.
There is, in fact, a more recent study than the Balda study called the Cornell study, which came to an exactly opposite conclusion, that in fact a white murderer charged with aggravated murder was twice as likely to be actually executed, and for the incredibly politically incorrect reason that for whatever reason white people tend to commit worse murders than black people. It's very hard to think of a black serial sex murder. The fact of the matter is you have to ask yourself, is there any case in which the death penalty is appropriate? I recently did a salon in a group where 90% of the people were against the death penalty, and I said, well, most of you in this room are, and elites of our society are, and they said, why is that? And I grew up in an upper middle class home. My own parents are against the death penalty. And I said, you're not going to like the answer. The answer is that, unfortunately, that most of you have never, and thank God, hopefully will never be touched by the kind of horrible crime and violence that occasions the need for the death penalty. And I would ask you to reflect on the fact of who is the victim of murder. A black man in this room is 7 times more likely to be murdered than I am just because of the color of his skin. The overrepresentation in murder is unbelievably high for women, children, and people of color. Thank you.
Well, I'd like to thank both of our speakers for very informative, engaging. Okay, now it's time to pretend like we're in merry old England. If you think Professor Haas won the debate, go this way. If you think Mr. Marquis won the debate, go this way. Thank you very much.